Good afternoon, everyone. I welcome you all to the webinar of ICSI IIP, that is Final Word on IBC. Today we have with us two faculties, Mr. Devul Dighe and Mr. Abhishek Anand. The first session will be taken by Mr. Devul Dighe. Let me briefly provide you introduction of Mr. Devul Dighe. He has done BCom, CS, LLM. He is a practicing lawyer. He regularly appears for resolution professionals and other professionals in national company law tribunals and also handling number of insolvency applications apart from other property, consumer, testamentary, trust matters and other commercial litigation matters. He has written several articles for which he received awards. He has written articles on Companies Act, arbitration and conciliation, etc. He has given lectures as faculty to insolvency professionals as a part of their pre-registration education course organized by the Institute of Chartered Accountants of India and Institute of Company Secretaries of India. He has also given various presentations on various associations on various topics such as AMTOI, Fire and Security Associations in India, Facilities Management Association, ATC Global Summit, etc., or on insolvency code for corporate persons and individuals. So you may now start the session.
Firstly, I would like to thank Anu for giving my wonderful introduction of mine. And I would like to wish a very good evening to all the members who have joined, various distinguished professionals who have joined this webinar. I would also like to thank ICSI IIP for giving me this opportunity. Today, my topic or the judgment that I have been asked to cover is Siva Industries judgment of the Honorable Supreme Court. Of course, I will be taking you all through the judgment and my views of it. But also, I have pointed out certain interesting aspects on that judgment, or probably what would be the position of law at certain facts of that judgment being altered or but little different. Because I believe today or tomorrow we will have to face a situation where such facts will also come before every one of us and before the honorable tribunals and Supreme Court for adjudication. So I will just start with the Siva Industries judgment. Then I will quickly come to my opinion on various aspects that it has now highlighted and various questions that it has created or various rights that it has enunciated. And then I will come to the certain interesting aspects of the judgment and questions that may come if the facts of the judgment were little bit tweaked or changed. So then that would be the third part of judgment and of our session, which we could have it in a very interactive way. So firstly, I'll just quickly run through the Siva Industries judgment. I know most of us would have read that judgment, and because it was not only a landmark judgment, but a very precise judgment and a short judgment in that sense, which talks about the commercial wisdom of the COC. So the bottom line is the commercial wisdom of the COC, but under what facts and to what extent and under what circumstances will the COC be allowed to exercise his commercial wisdom? That is a point that we'll come to a bit later. So as you all know, the Siva Industries judgment was based on a particular set of facts that I'll just go through quickly. First, in Siva Industries case, there was a CIRP order, and subsequent to that CIRP order, after the resolution professional having run through the CIRP process, obtained a few plans, and none of the plans were successful in a sense that none of the plans got the threshold percentage of voting, that is 66%. Subsequently, the RP filed an application for liquidation, and as rightfully he must have filed under 33(1) or 33(2), whichever provision he would have filed. But in terms of the provision of IBC, he was supposed to take the company into liquidation. Thereafter, it was at this juncture that the erstwhile promoter filed an application to the Honorable Adjudicating Authority for consideration of his settlement proposal and for withdrawal of the CIRP process. So this is one of the interesting facts that we must highlight, is that it was after the completion of the almost entire CIRP process, after none of the plans having been successful. It is at this stage the suspended promoter moved to the Honorable NCLT and sought a direction for its settlement plan to be considered, because this is the point that I will be highlighting subsequently also. Thereafter, the Honorable Adjudicating Authority directed the COC to consider a settlement proposal. Thereafter, again, as per the section 12A of the IBC code, the withdrawal or the settlement proposal did not achieve the 90% threshold limit, hence it was rejected. But subsequently, one of the financial creditors, that is AIRCL, who held 20% stake or thereabout stake in the COC, gave its consent to such withdrawal, thereby the 90% threshold limit being met. Subsequently, the resolution professional once again moved to the adjudicating authority to have a revoting being done on the said proposal. Again, we must really highlight this fact once again that there was a change of voting, or rather one creditor abstained from voting earlier, a proposal failed, and subsequently he changed his voting, and therefore he gave an affirmative vote after abstaining, and thereafter again a redirection was sought for a voting. So this is also one of the interesting aspects that we will cover, because this is a very short judgment, like I said. And thereafter, uh, the threshold limit was met. So the resolution professional filed an application under section 12A with all the compliances under 36. And thereafter, uh, that matter was listed before the Honorable AA. Now, the Honorable Adjudicating Authority at that particular point in time held that their section 12A is just for withdrawal, and it is not for settlement being per se arrived between the creditors and the promoters. Of course, this was not a case where there was a section 240A applicable where this corporate debtor was an MSME, and hence the suspended director or promoter was allowed to participate in the resolution process, which admittedly has not done. It was a case for withdrawal, and therefore the adjudicating authority, after giving a first direction for consideration of such proposal, after that having been approved, rejected that proposal, saying that this is not a simpliciter withdrawal, and hence this cannot go through, and also passed an order for liquidation, which was pending on an application filed by the RP earlier. These were taken before the Honorable NCLAT. Honorable NCLAT also dismissed these applications, and subsequently this matter met the fate of the Supreme Court's verdict, where the Supreme Court said that, look, the commercial wisdom of the COC is supreme. It referred to the BLRC report, as to why section 12A was inserted and why there was such a high threshold of voting rights being kept for COC to approve a withdrawal under section 12A, which is considerably higher than what the threshold is required for approval of resolution plan. And hence, once such a vast majority of creditors have approved the plan, there is actually no need for the adjudicating authority to interfere with the commercial wisdom of the COC unless it is arbitrary, malicious, or capricious, which it has actually held in various other judgments. But what is the most interesting part about this judgment, firstly, is the fact that once the CIRP process was about to be completed, a liquidation application was pending. Still, a resolution, a prospective suspended director was given an opportunity to submit a settlement proposal and withdraw a plan and withdraw the CIRP, which was initially was directed by the adjudicating authority to be considered. So this is the first interesting point that I feel in this judgment, is that even at the belated stage after which the resolution plans were considered and not approved, the adjudicating authority directed the COC to consider the settlement proposal of the promoter. Thereby, and this has been now upheld by the Supreme Court, so thereby we may have various situations in which a suspended promoter at as belated stage as after the approval of or after the rejection of a resolution plan may submit or may seek to enforce his right under section 12A and seek a direction from the honorable adjudicating authority for consideration of his withdrawal or a settlement proposal. And this, in my view, will go a long way in supporting the cause of CIRP, that if overwhelming majority of the COC approves, then it is always left to the COC's judgment as to what it does want to do with the company and whether the company deserves to meet the fate of liquidation, or should it come out of the liquidation. Second and most important thing here is now this judgment would of course lead to a number of suspended promoters and directors filing an application for withdrawal of CIRP proceedings at any stage of the matter. So one cannot now pick and choose that if in Siva Industries it has been allowed that you can submit it at such a belated stage, and other cases it should not be allowed. Because then you have to give a fair opportunity to every promoter to submit his withdrawal proposal at any stage that he deems fit. Of course, one of the interesting aspects that I thought was that what would have happened if the plan was approved? If the 66% here, it was a 60% threshold limit that had only reached, so 66% was not triggered for approval of resolution plan. But what would have happened if that 66% voting rights were in favor of the resolution applicant and subsequently this direction was sought and a 90% of COC would have approved withdrawal? So that we will, I think, discuss as in an interactive session later on. Secondly, once again, a very important aspect of law that I want to highlight before the honorable and distinguished members here is once there was a right available to a promoter under Section 12A to seek withdrawal at any stage of CIRP process, which has now been held by the Supreme Court as well. The rights available to such promoter, if he has exercised such right prior to the order of liquidation, should not be defeated just because subsequently the adjudicating authority passes an order for liquidation, like it happened in this case. So for example, if I, as a suspended promoter, file an application for consideration of my withdrawal or a settlement proposal, and in the meantime, there is a order application for liquidation pending by the RP, and I have chosen to exercise my rights, then should merely because adjudicating authority feels that this is too belated or not good a proposal because it cannot decide the proposal what I've given. It cannot exercise any sort of commercial wisdom on my proposal. So pending that my proposal being considered by the COC and I have actually applied to the RP or the adjudicating authority for consideration of my proposal, can adjudicating authority defeat my rights by passing an order of liquidation? This is also, there is a concept in law that a substantive rights that are once triggered by adhering to procedural provisions, then such substantive rights must be adjudicated prior to my rights being defeated by any other application. Because I have already set in motion my rights and I have sought the enforcement of rights through taking a procedure prescribed by law. So unless the law curtails my rights to have such rights adjudicated till the last extent, my rights cannot be made infructuous, as in this case would have happened if the promoter wouldn't have challenged the order of liquidation, or if the Supreme Court would have taken a very technical view, since there is a liquidation order already being passed, hence you cannot submit your withdrawal proposal and it has become infructuous. In fact, though you have submitted prior to the passing of order of liquidation, but it's become infructuous, then it actually defeats the rights of the promoter. So this is a very important aspect of the general law. Whenever we have seen that there are amendments made, there is a change in jurisdiction, a change in the procedural laws from one procedural law to another. Once I have triggered a procedural law for the enforcement of my substantive rights, and that cannot be defeated by a subsequent amendment or a decision by a court unless my rights are adjudicated, unless the law expressly provides for it. Similar was the case when there was a transfer from of insolvency proceedings from High Court to the NCLT. Similar was the case when Section 12A was amended. So you cannot defeat my substantive rights unless the law provides for the same. When I've set the same in motion, if I was sleeping over my rights, it's a different issue altogether.
Devul, won't
Yes,
this situation create a drag in the entire process then?
it would create a drag, but unfortunately, until the COC decides either ways, one way or the other, it cannot, the NCLT cannot, adjudicate upon this issue. in my respectful submission. So the ball has to come down to NCLT spot to be played in whichever.
In all practical terms, we already are dealing a situation where resolution plans are getting approved after 8 months, 9 months, and during the meantime, if the withdrawal application is given, which will again give a drag. So ultimately, we are not talking of the destruction of the assets of the corporate debtor, but we are talking of the fact that the situation is it's just dragging on and on.
That is,
I guess because recently once NCLAT judgment had come that once the RP has filed a liquidation application, then it cannot be turned around. Now what you are saying is Supreme Court has said that you can do a turnaround.
Yes, because in this case also liquidation application was much prior to even the settlement proposal being considered by the COC. So much prior in point in time. So basically what the Supreme Court has emphasized that because what has happened, there has been a judgment of the Honorable Supreme NCLAT on section 31, which says that, a plan comes into effect not when the plan is approved by the COC. A plan comes into effect when it's approved by the adjudicating authority. That is when rights crystallize in favor of the RA. And, all the benefits that he seeks under the plan, waivers, exemptions come into picture. So there is no vested right to him that once plan is approved by the COC, that accrue in his favor. And that was a judgment that was dealing with a case that home buyers had approached belatedly, for adjudication or for verification of its claims. And the NCLAT held that you can't defeat their rights in such manner. If they were, if their claims were evident from the balance sheet, you should have accepted it. Until the time the adjudicating authority does not pass an order under section 31, there is no right in favor of the RA. So RA can always modify the plan, and he cannot seek any benefit under the plan or enforcement of his plan.
No, but then in this case, what will happen is a plan got approved where the promoter either lost the plan or promoter could not participate because of section 29A. Okay. But after that, what will happen is once the COC is approved, now and gone, the application has gone by the RP to the adjudicating authority. Now he'll file the settlement offer and say that the COC should consider my settlement offer because I have a right and my right is not infructuous as per the law.
Yeah, but then again, it is a COC's prerogative whether it can simply dismiss, pass a resolution saying that it is not acceptable.
But as per the judgment, they have to first consider the settlement offer.
Yeah, it doesn't expressly say it so, but since it's allowed to one resolution applicant, it should be equally allowed to another resolution.
Exactly.
One suspended.
So again, it is a vicious cycle where if the settlement offer is larger or better or whatever it is than the resolution plan, then what will happen is COC will say whether he has given the proof or not in terms of whether that plan is implementable or not. But COC will say since the settlement offer is better, now you also up the ante to the resolution applicant. So this can lead to a situation where either it will go to liquidation again because there may be possibility the resolution applicant may say, no, I'll not up the plan. If you want to reject it, better you reject it now after accepting also. That's catch-22 position.
Very well a possibility, but again, it's like I said, what this decision at the end of the day highlights that it is the COC who has to decide whichever ways it does want to go. If it wants to consider that proposal, well, at whatever stage it comes at, it's their choice, and ultimately they have to, for withdrawal, you have to meet that 90% threshold. So then you have to get a greater number of people under your belt in order to get it approved. Again, this would also largely depend upon what is the structure of the COC. Many times, if unsecured financial creditors who may not get something in CIRP or liquidation may want to support withdrawal in ordinary case, rather than a secured creditor who may have ended up approving a plan. It may happen. There may be a situation like this, where the secured creditor passes a proposal for approval of resolution plan holding 66% or more voting rights, subsequently gets a better offer from the promoter, and unsecured financial creditors who earlier dissented because they were not going to get anything much, now think that if company is back on its legs with the erstwhile management, they'll get a better proposal, or a better payback. So they may end up supporting such proposal by the suspended board. But ultimately, it's for the COC in its commercial wisdom to decide where it wants to go. But now, of course, this judgment would lead to a situation where the suspended promoter would have its right, to give a settlement proposal. And one more important aspect that I wanted to highlight is here he had given one of the reasons why AA rejected that settlement proposal, saying that this is a settlement proposal and not just a simpliciter withdrawal proposal. So hence, this cannot take place under the realms of the IBC. While the Supreme Court says that, look, ultimately the COC passed a resolution for withdrawal, accepting that proposal. So if withdrawal is allowed by 90% threshold limit, so be it. So therefore you withdraw it. The commercial wisdom of COC is supreme. Whether that's what, of course, that settlement proposal may bind those signatories who ultimately sign for it, but it cannot get the benefits of a resolution plan. But it's a contract between, or a understanding between two creditors, or creditors and a debtor. You cannot interfere between that. A 12A withdrawal need not be based on a simpliciter withdrawal. On a simpliciter withdrawal application or a simpliciter withdrawal proposal, but it can be a settlement that has been worked out between the creditors and the debtors, or through the erstwhile management. Also, one of the interesting aspects that we must highlight here is whether, once there was a rejection of such a proposal, subsequently one creditor overturns his decision. He abstains earlier. Thereafter, he says that, look, no, I want to support this withdrawal. Then can this be permissible, and should the AA have directed the COC to do a revoting based on it? That is again one of the aspects that will come under limelight in many future matters, where a creditor might just change his voting, and then thereafter seek a consequential effect to such decision which his voting has. The consequential effect of change of voting which it has on the COC's decision. So can this be permissible? Of course, here what we must remember is one abstained and then gave a positive vote, and there was no other COC's plan that was approved. But the scenario would have been considerably different if he had rejected the proposal earlier, or if this would have happened in case of a plan where there were two competing plans, and one competing plan which earlier had a higher voting share of the COC was thereafter, there was another plan who got the even more higher voting percentage of COC because one creditor changed his decision. So well, then that resolution applicant can see saying that, look, now earlier though my plan was not approved, not because it didn't meet the threshold limit of 66, but it got 70% and somebody else got 80%. Now because of this creditor changing its line, I got 90%. Should not my plan be approved? So this is going to be certain aspects that are going to come into the picture. But then in my respectful submission, that will not be allowed in the future, just because, the RFRP and all other things spell out the manner of voting. The provisions of the regulations give you adequate time to, make your decision and cast your vote in one manner or the other. And if this is permitted, then that would lead to a sort of a renegotiation or rebargaining position with the creditors, which the RAs might try and do. So in my respectful submission, that will not be allowed. This was an exceptional case in a sense that there was no plan also being approved, and there was no other proposal that was there before the COC for being considered, and hence this was permitted. So there were 3-4 these interesting points that I want to, I wanted to discuss. One is, should this be submission of plan at such a belated stage be permitted? as a matter of routine by adjudicating authority? If not, what should be the the basic threshold limits or criterias or broad principles that a suspended promoter should meet in order to have its proposal considered? Secondly, the withdrawal limit or the withdrawal right to withdraw a petition should be exercised by the COC after, if had the plan been approved, can it still go on to approve the settlement proposal of a suspended promoter? And third, whether a change in voting should be permissible under some extraordinary circumstances by the COC. Once it has decided one way and it feels that it wants to reconsider its proposal, or one creditor wants to reconsider its the manner in which he has conducted, exercised his right, should he be permitted to change his voting right? So we can now open up for discussions amongst all the members. First, we'll take up the question whether this should have been permitted and what are the practical difficulties it can lead to. Because there can be 3-4 scenarios. One, you have a plan approved, then you have a post-admission approved, where 90% of the COC decides it. What happened if plan was approved by more than 90% of the COC or 100% of the COC, and thereafter a proposal for withdrawal comes in? Because if 100% COC voted in favor of the plan, then it is greater than the 90% threshold required for 12A. And what would have been the situation? So we can discuss these aspects, and because these are the interesting aspects that are going to come forward, and Siva Industries basically deals with this brief set of facts. Also, if any applicant has any questions, I would be free to answer, or we can have a discussion on that question.
Yeah. This is Ashok Jain. I'm audible.
Yes, sir.
Say, ultimately, the question is not the stage of the CIRP process, whether it is admitted, whether there was no application touching to the requirement of the plan, or it may be at the stage of liquidation. What I understand from section 12A, that simply the adjudicating authority can allow the withdrawal. They have not mentioned anything about the compromise settlement in the section itself. So I want to understand from you that when the 12A says a simple thing that it can be withdrawn by either applicant, maybe CD or some creditor, with the 90% majority of the COC. So what I simply understand is that there is no precondition given that it should be at any stage, or it should be up to that particular stage. So in this case also, since it was the liquidation application was filed, and then the application for withdrawal was given, later on supported by one of the COC member completing that 90% requirement. So in any case, not only this case, can withdrawal happen at any stage, maybe because of compromise settlement or some other reason?
So, sir, I perfectly agree with you that 12A does not prescribe any stage at which the 12A power can be exercised by the adjudicating authority. It can be from any stage up to the passing of the order of liquidation. After liquidation, in my view, it cannot happen. 12A cannot come into the picture simply because CIRP does not survive once the liquidation order is passed. So therefore, there is no question of 12A coming into the picture at that particular point in time. And there is no COC also at that particular point in time. Of course, you have the stakeholders committee, but the stakeholders committee does not exercise the same powers as COC in a CIRP does. And the 12A is quite explicit when it covers the stage of CIRP process only. So in my view, it can be it rightly as held by the Supreme Court, it can happen at any stage of the CIRP. But the question would have arisen is that, look, if I there can be two situations. Either you are a promoter and you are ineligible under 29A, or you are an MSME, hence you are a promoter and you are eligible under 29A. In both these circumstances, you have, if you come up at a belated stage, then you have the advantage of knowing what is the proposal being given by the other RAs. So you are going to take an undue advantage of that. Because now you have series of judgments that promoters also have to effectively participate in the CIRP process. So now, once they are aware of the broad commercial parameters that have been offered by the other RAs, competing RAs or non-competing RAs in case they are ineligible, then does that not give you an advantage to give a better offer and wait till the last moment to decide whether you want to exercise your right under 12A or no?
But at the same time, they will, other RAs also will get the chance to up the ante.
That may be so.
Take it this way, they will. Let's say all the other, there were some 3-4 RAs, proper. Let's say there was a competition of 4 or 5 RAs who gave the plan. And the plan is, let's say, more than the liquidation value. I'm just giving a perspective of hint of more than liquidation value. But in terms of fair value, it's far less. And no one knows better than the promoter. Okay. So promoter ups the ante saying, okay, I'll give you a better offer. This is the way it is. Where probably he will say, because he's in a position to say that I'll give operational creditor a better payout, bankers better payout, unsecured loans better payout and all. Now this, if leads to better competition or better or maximization of the value, I don't think so there is a problem. Only the problem is there should be a time period constraint. That he cannot, that entire effect of that entire process, which gets extended due to his withdrawal or settlement offer after the successful of one resolution plan, should be like 30 days or 60 days, whatever it is. Otherwise, the purpose will be defeated because it can go for another 1 year also.
No, so that, see, it may create a competitive atmosphere, but it should not ultimately. Now the Kotak Bank's judgment of the Supreme Court says that now let us bifurcate this into two parts simply. One is a part where he was eligible. So if he does not participate in the entire process of submitting an EOI and other things, the Kotak Bank judgment clearly says Tata bye-bye to him. So he can't participate, in this plan submission, in the submission of a resolution plan. In that case, okay, one may say he only now has the option of going for a 12A. Then he sees the competitors, bidding, and if he gives a revised bid, then that is okay. But what we must also understand that ultimately in a 12A, you are only permitting a withdrawal. You are not approving a restructuring or a resolution. So, though there might be creditors who may, of course, the creditors have to exercise their rights in favor of it. But then that leads to a situation where there might be certain creditors who might be okay with the situation of the company coming out of the CIRP, but would not be okay with taking a resolution, at the same time. So that will again create, two classes of creditors who will then.
So again, it will get rejected. No, the 12A will get rejected because 90% threshold is there. So it means to say that all the COC members, literally, I would say rather, literally all the COC member has to be in sync in that matter. Otherwise, it will not succeed, no?
Yeah, that is the basis of the Supreme Court judgment also. But it gives an unfair right to the promoter to, come up at the back stage. And secondly, if there was a vested right in favor of a resolution, I think Mr. Bansal's mic is on.
See, in practical terms, we know in all practical terms that promoter can come in a lot of ways. Many times they are in hands in sync with an RA. So, and since he has the power to get all the resolution plans, being part of the committee or being part of the entire process, still he can support the RA where he can get a stake and all. So those are factors. But I believe nothing wrong as such. Like, I know there will be a delay on the matter.
Wrong. It is just going to create a series of other questions that
other questions and delay in the process. I agree.
Yeah,
with
so
you.
This might be a tactic to delay the process. I don't know whether my plan will be approved or not.
I can take it 100% of the cases it is going bound to happen. Now
Yeah,
it will be bound to happen because it's a Supreme Court judgment. It's no one else.
So even I have a couple of cases where the promoters are seeking withdrawal or under 240A, there are some MSME companies where the promoter wants a right now to submit a plan after it participated in the OI process, subsequently failed to submit a plan, liquidation application is pending, and subsequently after receiving some funds or some sanction letters from some other banks is suddenly dropping in to submit a showing their interest to submit a resolution plan or a withdrawal proposal. So these are going to open up a lot of questions, and that is why precisely we are here to discuss this. In my opinion, as far as MSME goes, if you don't participate, sorry, goodbye, because you have already had an opportunity to submit a plan which was had a lesser threshold, which you could have got a better deal with the COC, binding entire COC, but you didn't exercise. Vis-a-vis what has happened in Seva Industries case, where you are not eligible, you may submit a withdrawal proposal at any stage. It doesn't matter. 12A, there is no embargo. But at the same time, one has to consider a situation. If there was a approval of a resolution plan, then ideally it should not be allowed for the promoter to now come in because the COC was happy with a certain proposal. Of course, if he gives a better proposal, and ideally, of course, the unsecured creditors might vote in a given set of circumstances in favor of the promoter and get the 90% threshold limit. But ideally, in a given situation, it should not be allowed unless there is a genuine bona fide shown. Because otherwise, this will lead to a situation where you will have a prolonged litigation.
And therefore, here is a question, say, though IBC is a latest piece of legislation for resolution of the cases. Now, ultimately, the idea is the better recovery or maximization of value. If I go by that idea, at any stage, even, always we know that in 90% cases, what we get out of the liquidation, execution of the liquidation order. Even it is 10%, 20% of the outstandings claims of the different creditors. Now, even if after the liquidation order, I will come to this extent. Say earlier in the DRT cases, even after decree is passed, because execution of decree was difficult, so compromise settlements are still being done by the banks. Here, all the stakeholders are the same. When the creditors and the debtor, maybe earlier he has not availed the opportunity or he has not come forward with a proposal for settlement which is acceptable to the creditors or the COC or the banks. Now, if he is coming at a late stage also, and if there is a seriousness, we can immediately recover the amount if we compare both the processes through liquidation, execution, or if through that compromise route, which is PPIRP is also, it's a sort of that step only in that direction, that yes, the person under MSME, MSME category fellow can come forward and can submit a proposal which is more or less a compromise come restructuring option. So here also, because now this order would open many questions, but ultimate idea is that if we are able to recover the amount, if there is a maximization value, and if there is seriousness in the proposal, adjudicating authority can always consider such request at any stage. What do you say?
Yeah, that's true. See, but the point is, in liquidation, then there are routes that are prescribed. You can go under a compromise arrangement and get your debts restructured. So the within the realms of the law, settlement is always something that I think any court prefers, because everybody knows how painful execution is or liquidation is, in any court, and in civil matters, so particularly it's a very painful exercise, because sometimes you get a decree in 3 years, but you may have your execution going on for 10 years. In the meantime, like you said, if something happens in like CIRP comes up for a corporate debtor, your right is again defeated, because you end up getting nothing after litigating for 10 years also.
Correct.
That is something, of course, all judges encourage and must be encouraged. But it will be only a question that what would happen when there are two conflicting interests, who are giving a two conflicting good offers, and one is a promoter, one is an RA who adhered to the entire route, got his plan approved, and then has to await the outcome of promoter coming into the picture and providing a settlement proposal, because this can be a tactic to frustrate him also. Because most of the time, like in real estate projects where I've worked now, in 2 3 big assignments, this is a tactics that is done by a set of promoters, to frustrate the RA, because for them there is an escalating cost. They have other proposal, other land banks to develop, and if that land banks, if they keep waiting for this proposal to come in and do not take, make up most of the opportunity that they have outside, they might end up losing, the opportunity cost, what they call it, that is a 1% or 2%, however they term it. So, again, this is also a tactic that can be employed to frustrate PRAs, given in a situation, especially if there was some, plan that would have been approved at that stage. If there was no plan, no concrete proposal, of course, the nobody would mind promoter, like in this case, from coming up and giving a good settlement offer. But had there been a plan, things might have been very much different.
Yes.
Also, any other questions that any other participant has, or any other things that we can discuss? So also, second aspect what we can discuss is quickly before the second session starts, is whether this exercise of change of votes, or rather once you abstain from voting and thereafter you decide to change your vote and give an affirmative vote as done by AIRCL in this case, must be permitted. So in my, again, this is a little exceptional set of facts. In my view, because it didn't prejudice the rights of any other creditors, applicants, one would say, okay, there is no harm, because it, supports the overall objective of the IBC, that is the maximization of value. But had it this been the case of a voting on a competitive plan, and this should not have been permitted, simply because then you have a possibility of renegotiations and opening an entire floodgate of backdoor renegotiations and revisions of plan and litigation subsequently thereto, which I believe it is against the spirit of the IBC. You were well aware in advance what was the plan, what was the commercial offer given to you, and you were well given ample of time to decide which way you want to vote. And once you have voted or abstained from voting or given a negative vote, you must stick by it, ideally, unless there was a fraud. Of course, fraud and coercion and all these are exceptional grounds which renders any act nullity. But except that, then that is binding upon you. In this case, since there was no other RA that was there in the picture and settlement was better than liquidation, one would say that in such circumstances it was very well permissible to do so, because there were no conflicting interests.
Now here, Mr. Devul, just I would like to submit. Say, now there are two things, two angles to think over it. One is that normally what you say is very correct, that once any stand is taken by any stakeholder or creditor, it should be maintained. That is right. But ultimately IBC law or regulation is silent on this. Can I change my stand? As per my understanding and knowledge, there is nothing mentioned in any regulation or any IBC sections anywhere. Now, ultimately, if somebody is changing the stand at a later stage, maybe the cases, conditions would be different. Here, it was not adversely affecting anything, so it is okay. By and large, it's okay that, okay, if somebody has changed that. But ultimately, if there is a problem of final decision because of the first stand taken by all the COC members, looking to the practicality of that particular case, if we can come out with a better solution of the problem, if it is stick somewhere, then if somebody changing the stand to support that, so that the final solution or resolution can come. Well, what do you think that it can be done, or it can be permitted, or it should be accepted?
So, in my view, it should be only permissible at the stage where it does not prejudice the rights of any parties. Apart from that, it should not be permitted simply because, entire IBC exercise at the same time is an exercise that is time bound exercise. You are given uh, a decent opportunity to go through the information on the particular decision that you have to take, whether it's plan approval or any other thing. When you have been given an ample of time or as permitted by the court to go through the contents of the plan or other information in order to decide which way you want to go, and including giving you a right to abstain from voting. Now, once you have exercised that right, then you should not be allowed to change your decision unless if it prejudicially affects any other creditor, because otherwise that is against the spirit of the IBC. Because many times again, what happens is, I'll tell you, many a times in again predominantly in real estate industry, you as a dissenting creditor do not get much of value, because sometimes what happens is when you are having a real estate project and home buyers are given a proposal that, look, if you dissent, you get the liquidation value. If you assent, you get your allotment of your flats. So most of the times, or for some minor unsecured financial creditors, if that is a proposal, then many a times they are really disincentivized to vote against the plan, because if they know if they vote against the plan and if they're in minority, they'll get nothing. Better than you go in affirmative vote, at least you maybe after 5 years, maybe after 10 years, you will get your unit. But if you vote against it, there are other creditors who will pass the plan, but you will get nothing, because many times the plan is worded in such fashion that if you are a dissenting financial creditors, whatever is the liquidation value, I'll pay you. Now, many a times they know that liquidation value, especially when secured creditors are there, is virtually nil. Then I offer you 20%, tell you to vote or either take the dissenting value. Then it becomes a game of percentage. So again, all these things have to be kept in mind while we allow these things to happen. Of course, the Honorable Supreme Court will decide, but I believe that if it prejudicially affects any creditor, it should not be allowed.
That's right.
So anybody has any other questions or anything to discuss? I think we have last 7 to 8 minutes before the next speaker can take over. So Anu,
Finally, can we take a clue from this decision of Supreme Court that in case of any case pending with NCLT and at the different stages of CIRP process, if any withdrawal application with 90% support of COC along with some alternative proposal, which is not mentioned, of course, in 12A, it says it simply talks about withdrawal only. But there has to be some reason for the withdrawal. Normally, it would be a settlement between the parties. So, can we take a clue from here that yes, now in any case, if such situation rises, we can always go for a withdrawal and subsequent compromise settlement?
I think definitely, and I think more important to that is because withdrawal is based on a percentage vote. So of course, if it passes the muster of 12A, it must be allowed. But what more specifically it states that at any stage, if a proposal comes in, then it sort of must be placed before the COC, either directly or in this case through the route of the adjudicating authority, before the COC, and the COC must decide whether it wants to accept or reject such proposal. So it actually goes on to say that, look, once you receive such a proposal, ideally, you must place it before the COC and let the COC have a go whether it wants to approve it or reject it. But he must be given that opportunity that his proposal is being considered by the COC one way or the other. It can't be that he is just at the outset told that because a certain stage of CIRP is going on, his proposal cannot be considered.
Because one more solution can be done by the COC to reduce the time period. They can give an offer to during the process of the resolution plan being considered. They can tell the promoter to give their offer as per the 12A, which can be considered by voting at one go, instead of getting a surprise letter on where he files the 12A.
To carry, that if you, but then again, the point with this, the problem with this is that, hello, am I audible?
Yes, sir.
Yeah, you are audible.
So the problem with this is then, against the without there being an express provision, you are sending an invitation to them, and ultimately then you are bound by such invitation. And secondly, then the only problem is then you can't, whenever there is a
See,
plan
we know they
considered.
will, but practically they will, even the COC will understand that now that we are not entertaining the promoter. Promoter is again going to give 12A after the plan is approved by of someone else.
So he can do
instead
that
of
anytime.
Yeah, he can do any time. So again, doing a harakiri, it's better, delaying the process. Say whether you are interested or not, because the law says so. It's better you do it now so that we can decide at one go for everyone.
Yeah, but that would, I would certainly say that's a very good idea.
A promoter cannot file multiple 12A application. Once his 12A application has been rejected, chapter closed. But then problem happens is once a plan is approved of a resolution applicant, then he files a 12A or settlement kind of thing, whatever it is. Going back to the drawing board, doing the entire process again, and then taking a decision and then going to educating authority is more nuisance value. Means I just think in terms of time period.
Yes, I certainly agree that it's a good idea, but again, that this thing would require a specific, regulations coming into picture that after the, COC plan, resolution plans being considered, this should not be permitted. That they should not be permitted to come. Otherwise, the thing keeps going on. The promoter will keep coming, with this sort of an issue. And same thing again, one will ask the question to the promoter that why were you sleeping all this while and you waited till the last day to file your application or bring your proposal on the table.
But then that has been already negated by judgment of Supreme Court. I'm sure Supreme Court must have taken a judgment of a case where he must have gone after all the processes failed. So Supreme Court, if Supreme Court has allowed, how can someone question that why you are coming at the last stage? Nobody will do.
So
Only the thing is, and second thing is, if we say that RFRP says that you cannot file a 12 application once the plan is approved, again Supreme Court, if he is challenging Supreme Court will say, no, his right cannot be undermined by the RFRP. I feel so.
That is correct. And because then that RFRP clause becomes violation of 12A. So a clause of the RFRP cannot be violative of section 12A. So again, this would be a part of practice, but ultimately the bottom line is it is COC's wish. Whatever they want to do, they can do it, provided it's not arbitrary or capricious. So that will be, I think, the bottom line of it. As far as other issues are concerned, I have already given my opinion. I don't know how the Supreme Court will take it in a given set of circumstances, but this would be a very interesting aspect that I thought we could draw from this judgment, because otherwise the judgment is a very precise judgment that deals with the fact, or that underlines the fact that started from Swiss ribbons and all the way through, that commercial wisdom of the COC is paramount. but these are some interesting aspects that I thought we could cover in today's session. And I think we are about to end our session, so I will not take away the time of the second speaker. So Anu, are you there?
Yes, sir. Thank you, sir, for the session. It was very interactive, very informative. Thank you so much.
Thank you.
Thank you, sir. So now the next session will be taken by Mr. Abhishek Anand. Mr. Abhishek Anand is a New Delhi-based corporate and commercial lawyer and has over 13 years of experience in the legal profession. He is a law graduate from the University of Southampton, UK. And prior to returning in India, he has worked as a legal consultant with Goldman Law Solicitors, London, UK. He has attended various international and domestic conferences, including 3rd International Competition Law Conference 2016 and Insol International Conference India Chapter 2016. Mr. Anand is the founder of the firm and has been actively advising insolvency professionals, financial institutions, corporate clients, and resolution applicants with regard to the resolution or liquidation process. Mr. Anand has extensive experience in handling matters independently before the Honorable Supreme Court, High Court across different jurisdictions, and tribunals like National Company Law Tribunal, National Company Law Appellate Tribunal, Board for Industrial and Financial Reconstruction, Appellate Authority for Industrial and Financial Reconstruction, Appellate Tribunal for Prevention of Money Laundering, Electrical Tribunal, Petroleum and Natural Gas Regulatory Board, Debt Recovery Tribunals, and Debt Recovery Appellate Tribunals, etc. So you may now start the session.
Thank you, Anu. Good evening, everyone, and I thank the Institute to giving me this opportunity to speak on the recent judgment by the Honorable Supreme Court in the case of PTC India Financial Services Limited. So I have just jotted down some short presentation in keeping in view the time. So I'll just share that presentation on the screen. Anu, any preferences are required for the purposes of sharing, or you can see?
No, it's already shared. It is visible.
Okay. All right. So today we will be discussing the judgment of the Honorable Supreme Court in PTC India Financial Services Limited versus Venkateshwaralu, Curry and another. And the issue which in fact was before the Honorable Supreme Court was a legal issue involved in the judgment with respect to whether the Depositories Act 1996, read with Regulation 58 of the SEBI Depositories and Participants Regulation 1996, has the legal effect of overwriting the provisions relating to pledge under the Indian Contract Act 1872 and the common law as applicable in India. So this was the question which was before the Honorable Supreme Court. So before going into the presentation, I'll just give an overview, brief facts. What was before, why this civil appeal was filed before the Honorable Supreme Court, under what facts and circumstances the issue arose in a CIRP of a corporate debtor, although the question relates to the overwriting of provisions between two different acts, one being the Depositories Act 1996 and other being the Indian Contract Act 1872. Now, why did this situation in these facts and circumstances arose is because of the facts of this particular case. Now, a company called PTC India Financial Services Limited, which is a wholly owned subsidiary of PTC India Limited. So we'll call it as PPIL, was the appellant before the Honorable Supreme Court. PPIL granted a loan, which is a bridge loan agreement, by virtue of a bridge loan agreement in 2014 for 125 crores to a company called NSL Nagapatnam Power and Infratech Limited, which is NNPIL, which is the corporate debtor who originally filed a Section 10 application before the NCLT Hyderabad bench to initiate CIRP suo motu under section 10. So there was no other creditor who had originally filed the CIRP proceedings. In terms of the agreement, whereby the financial assistance was granted by PPIL to NNIPL, on 10th March 2014, a company called Mandava Holding Private Limited, which is the holding company of the corporate debtor, executed a pledge in favor of the appellant, which is PPIFLSL. Now, this will sound all, because there are too many companies involved. To make it in a brief, the appellant company is the lender, corporate debtor is NNIPL. The holding company of the corporate debtor is called MHPL, that Mandava Holding Private Limited, who had two subsidiaries. One, the corporate debtor, and another subsidiary called NEVPL. Now, while the loan was granted by PPIL to the corporate debtor, the holding company MHPL gave as a security a pledge of 31,80,768 shares of the other subsidiary company, which is NEVPL, to PPIL as a security for giving the financial assistance to the corporate debtor. So the basic transaction was that the appellant granted a loan to the CD. The holding company of the CD granted security as a pledge of 31,80,670 shares of the another subsidiary company in favor of PPIL. 2017 default, the corporate debtor files an application under section 10. Section 10 is admitted by the NCLT Hyderabad bench and the CIRP proceedings commenced. Now, before the section 10 was admitted, default was there by the corporate debtor, and by virtue of that default, PPIL invoked the pledge and issued a notice, which is required under section 176 of the Contract Act, to MHPL as the corporate debtor was in default. And ultimately, PPIL became the beneficial owner the moment invocation of that pledge happened. Now, when CIRP proceedings started, as everyone here is aware that public announcement is made and the IRP then invite claims. Now, while those claims were invited by the IRP, both the holding company of the corporate debtor, which is MHPL, and the appellant, the lender, PPIL, filed their respective claims before the IRP, claiming to be a financial creditor. The IRP, after verification, rejected the claim of MHPL on the ground that the same could not be crystallized. IRP also rejected the claim of the appellant, which is PPIL, on the ground that the settlement in whole or part of its claim having the status of beneficial owners of those shares which have been pledged of the subsidiary company. So in sum and substance, both claims were rejected by the IRP. For the lender, it was said that you have already invoked the pledge. Therefore, you having become the beneficial owner will not have any claim against the corporate debtor. Insofar as MHPL was concerned, the IRP rejected on the ground that the amount has not been crystallized, so therefore no claim. Now thereafter, both PPIL and MHPL filed applications before the NCLT against the rejection of their claim by the IRP. The NCLT, by a common order of 6th July 2018, in fact dismissed the applications and held insofar as the appellant is concerned. So far as MHPL is concerned, because the issue is not before the Honorable Supreme Court, we will not be discussing it. They had accepted the claim by relying on Regulation 56 and the Depositories Act, and to say that MHPL will have a claim against the, and the claim was admitted. However, the claim of PPIL, the application, was dismissed by the NCLT, and NCLT observed that because they had exercised their right under the pledge deed to transfer those 31,80,678 pledged shares, the holding company shareholding got reduced by those shares, and therefore they treated the PPIL to be the beneficial owner, and therefore their claim could not have been maintained in the CIRP of the corporate debtor. And accordingly, the application came to be dismissed by NCLT. Against that, under Section 61, an appeal was filed before the Honorable NCLAT. Honorable NCLAT also dismissed the appeal of the appellant and observed that because they had already exercised their right under clause 6.1 of the pledge deed, and consequently the pledge shares to transferred, and they had not in fact sold those shares under clause 6.2 of the pledge deed, under Section 176 of the Contract Act, because you have two remedies available under 176 of the Contract Act, one being either you can sell the goods pledged to you, or you have a right to sue insofar as the pledge is concerned. Now, the Honorable NCLAT also upheld the decision of NCLT and held that the moment the right to become the owner was exercised by the PIFSL, PIFSL cannot take advantage of Section 176 to claim the debt. So in sum and substance, what NCLAT held was that you can't now exercise the rights available under 176 of the Contract Act with respect to those two options available, one being sell the shares, second being right to sue against the corporate debtor. So the moment you don't have those two remedies available, NCLAT held you can't be treated as a financial creditor of the corporate debtor. Against that order, this present civil appeal was filed before the Honorable Supreme Court. And in this civil appeal, the question which was framed to be decided was this, what we have just considered, that whether the Depositories Act, Regulation 58 of the SEBI, has the legal effect of overwriting the provisions relating to pledge under the Indian Contract Act and the common law as applicable in India. And second being whether PIFSL has the right to take advantage of Section 176 of the Indian Contract Act for reclaiming the debt in the CIRP of the corporate debtor when PIFSL has not sold the shares under clause 6.2 of the pledge deed. So these were the primary questions framed by the Honorable Supreme Court to be decided in this matter. Now, this judgment, in fact, goes into the key provisions of the Contract Act, the Depositories Act, as well as the regulations, which are the SEBI depository and participant regulations. So we will be looking into only those key provisions which concerns the questions and the findings given by the Honorable Supreme Court, because Honorable Supreme Court, this judgment is of 86 pages. The Honorable Supreme Court has gone from entire law on the point of the pledge and mortgage, and different aspects with respect to what happens and what right a pawner or a pawnee has insofar as the pledge is concerned. But today we will be only looking at from an angle where the questions which were framed, what were the findings given by the Honorable Supreme Court, and to understand that whether PIFSL could have been a financial creditor of the corporate debtor, or in another way to put it, whether they still have the right to enforce under section 176 of the Contract Act, having not exercised that right at the time. So under section 172 of the Indian Contract Act, the definition of pledge, pawner and pawnee has been defined. Now, the bailment of goods as security for payment or debt or the performance of the promise is called a pledge. So in general meaning, anything given in security for payment of a debt or performance of that promise is called a pledge, but that is different from a mortgage. This can't be treated as a mortgage, because in mortgage, there is a transfer of right of ownership to a certain extent. Whereas insofar as the pledge is concerned, it is not a transfer of ownership right. It is only a beneficial right, which is there till the time either the performance is not completed as promised or the payment of debt is not made in terms of the pledge for which that security has been given. Now, who is the bailer? The bailer in this case is called the pawner. The bailee is called pawnee. So basically, the person who is given the security is called the pawner, and the person who is taking that security is called the pawnee. So meaning thereby, in this case, PFISL becomes the pawnee, and corporate debtor who had pledged the shares of NEVPL becomes the pawner. Sorry, MHPL is the pawner, because the holding company of the corporate debtor becomes the pawner. Now, under the Indian Contract Act, there are various provisions, which in fact in the slide we have only gone through the relevant ones, but we can go through certain more provisions of the Indian Contract Act, whereby in order to understand that what is the scope with respect to the pledge, the rights of the pawner and the rights of a pawnee. Now, under section 176, what right a pawnee has when the pawner makes that default is with respect to provided under 176. So it says, if the pawner makes default in payment of the debt or performance at the stipulated time or the promise in respect of which the goods were pledged, the pawnee may bring a suit against the pawner upon the debt or promise and retain the goods pledged as a collateral security, or he may sell the thing pledged on giving the pawner reasonable notice of the sale. If the proceeds of the sale are greater than the amount so due, the pawnee shall pay over the surplus to the pawnee. So 176 provides two things. 176 says that the moment 176, yeah, that the moment the pawner makes a default, either in payment of debt or in the performance, the pawnee is entitled to two things. One, he can have a right to sue against the pawner on the default, and he has a right to retain that goods which have been given as a security, or he may sell the thing pledged on giving the pawner reasonable notice of sale. So only two remedies available upon such default. Now, 176 or any other provision of the Indian Contract Act does not provides what is this reasonable notice of sale. Because under 176, what is provided is that he may sell the thing pledged on giving the pawner reasonable notice of the sale. Now, this reasonable notice is not defined under section 176 of the Contract Act or any other allied provision under the Indian Contract Act. The law has been laid down by the Honorable Supreme Court in various decisions, wherein it has been held that question what will be the period notice, what will be reasonability of that issuance of notice will depend upon facts of each case. So in one case, there may be an agreement between the parties to say that upon default, reasonable notice will be 7 days, but in some case it will be 15 days. So there is no mandatory provision provided under the Indian Contract Act that the notice must be of 14 days, 10 days, 7 days. No. So it will all depend upon the facts of each case, what will be the reasonable notice with respect to default being made by the pawner. Now, there are various decisions then considered by the Honorable Supreme Court in the present judgment, and the law with respect to what is reasonable or what is not reasonable has been discussed, which today the time does not permit to go into, because today we are only on the overview of the judgment. Now, section 179 then says with respect to what interest the pawner will have the moment pledge is made. So 179 says where a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that interest. So to give an example, a property may be owned by 3 co-owners. 1/3 co-owner may give that property as a pledge, but the pawner will only have the right with respect to that 1/3 share of that property, because that is limited to that extent, that interest which has been created in his favor. Under the bankruptcy law, a pawner will become a secured creditor, whether charge is registered or not registered, under the bankruptcy law. But obviously under the insolvency law, we have a mechanism to see that whether someone is a secured creditor or not. And by the recent judgment of Honorable Supreme Court in Rainbow now, that law in fact has been diluted to a certain extent, that even under the Gujarat VAT Act, a lien mark would be treated as a security interest. So a pawner, in fact, in a bankruptcy proceedings will definitely be a secured creditor. That's what the Honorable Supreme Court in this judgment have also held. While, although that was not the question, but while discussing the law of India on 176, what rights the pawner has, the Honorable Supreme Court has dealt with the said issue. Now, as everyone is aware that, you see, prior to the Depositories Act, there was the pledge being made of shares was by handing over the physical share certificates to the pawner. Now, subsequently, when the act came, which is the Depository Act of 1996, it provided that all these securities shall be held by the depository in a fungible form, which basically says that the depository will become the owner, being the registered owner in respect of that securities, whereas the person who surrenders the physical share is recorded as the beneficial owner. So by virtue of this act, one thing was clarified, that the depository will become the registered owner in respect of that security, and the person who surrenders those physical shares will be recorded as the beneficial owner. Now, the beneficial owner, in fact, will only be entitled to the rights, benefits, liabilities attached to those security held by the depository. And this act was in fact provided, the preamble of the Depositories Act 1996 provides that it's an act to provide for regulation of depositories in securities and for matters connected therewith or incidental thereto. Now, we are not going through each and every provision of the Depositories Act. We are only concerned with Section 12 of the Depository Act, which provides pledge or hypothecation of securities held in a depository. This section is relevant for the purposes of this judgment. Subject to such regulations and bylaws as may be made on this behalf, a beneficial owner may, with the previous approval of the depository, create a pledge or hypothecation in respect of a security owned by him through a depository. Subsection 2 provides every beneficial owner shall give intimation of such pledge or hypothecation to the depository, and such depository shall thereupon make entries in its records accordingly. Any entry then it's provided with respect to further, with respect to that it will be an evidence with as recorded in the depository. Now, Section 12 of this Act concedes that the securities held by the depository can be pledged and hypothecated by the beneficial owner. It simplifies, in fact, the process by bringing transparency. It checks and curtails possibility of dispute as the pledge must be registered with the depository. So that's the preamble and the intent of the Depositories Act. We are only concerned with Section 12 with respect to pledge. Another regulation, because what we are going through today is those three provisions, because the question which was framed by the Honorable Supreme Court dealt with and considers these three provisions, one being the Indian Contract Act and second being the Depository that whether the Depositories Act read with Regulation 58 will overwrite the provision of the Indian Contract Act with regards to a pledge. Ultimately came and became a question for an IRP who was considering the claim in the CIRP process, that whether he should admit such claim or should reject that claim. Now, obviously, in most of the CIRP cases, the claims are much more simpler to say that very rare cases will have claims like these. But ultimately, the Honorable Supreme Court has laid down this law now, whereby they have dealt this question. So Regulation 58 of SEBI Depositories and Participant Regulation 1996. What is this regulation? This regulation is that subject to the provisions of pledge document, the pledgee may invoke the pledge, and on such invocation, the depository shall register the pledgee as a beneficial owner of such securities and amend its record accordingly. So this means, applying this to the judgment in hand, it means that subject to the provisions of the pledge document, the pledgee, which is PIFSL, who is the appellant before the Supreme Court, may invoke the pledge being the shares pledged by MHPL for the loan given to corporate debtor, and on such invocation, the depository shall register PIFSL as the beneficial owner of such security. This means that the fact that before the CIRP commenced, PIFSL invoked the pledge and gave a reasonable notice under 176 to MHPL that, look, the corporate debtor is in default and therefore I am invoking the pledge, and in terms thereof, the 31,80,768 shares of any VPL will then be registered by the depositories as a beneficial owner, being the PIFSL of such 31,80,678 shares. Now, as per these regulations, the pledger is not entitled to sell the securities which have been pledged. The special rights of the pledgee in the pawn remain intact under the Depositories Act. However, the right to sell dematerialized securities is conferred and given to the beneficial owner, who exercises this right through the participant. Consequently, if a pawnee wants to exercise his right to sell dematerialized security, it is mandatory for the pawnee first to get himself recorded as a beneficial owner in the depository records. Now, this is very important, because if this is not done, then you will not have the right. Without the said exercise, the pawnee cannot exercise its rights to sell the pledge and retrieve the money due by taking recourse to its rights under section 176 of the Contract Act. Now, these three conditions, in fact, will then become relevant for an IRP while considering a claim, to while verifying the records and the documents and the claim, to see whether the pawnee has in fact exercised his right to sell the security or not. If he has, then whether he has complied with the mandatory requirement to get himself recorded as a beneficial owner in the depository or not. Now, without this, then he could not have exercised the right to sell. If not, then the answer will come in the affirmative. If he has not, then the answer will be in the negative for an IRP to consider the claim in the CIRP. Now, the findings of the Honorable Supreme Court with respect to, after, I hope you have gone through the judgment. If you read the judgment, the Honorable Supreme Court has gone into each and every provision of the Indian Contract Act with respect to the pledge. The Honorable Supreme Court have then dealt with the Depositories Act, the regulations, and in fact answer various questions that, with respect to the law laid down by the Honorable Supreme Court on the issues which concerns consequential reliefs under the Indian Contract Act for a pawner and a pawnee. Now, after going through the provisions, the analysis and the findings which the Honorable Supreme Court has given are briefed herein, which are that the contract of pledge envisages that PIFSL is entitled to get itself recorded as a beneficial owner without forfeiting its right in terms of clause 6.2 to sell the shares. So if you recollect regulation 58, it provided subject to what is written in the pledge document. Now, in this case, what is written in the pledge document is that under clause 6.2, they are entitled to get themselves registered as the beneficial owner without giving up or forfeiting their right to sell the shares. Now, the contention of MHPL was before the Honorable Supreme Court was that clause 6.1 and 6.2 are in the alternative, and once the appellant had exercised options under clause 6.1, the option under 6.2 is closed and must be rejected as untenable. Further, PFSL could not have exercised the right under clause 6.2 unless the pledged share were registered in its name as the beneficial owner. This step was necessary to enable PFSL to exercise its right and enforce the sale of pledged shares. Now, obviously, this is flowing from the regulation 58, read with section 12 of the Depositories Act. The argument was that because they have already exercised the right and become a beneficial owner, they could not have exercised their right to sell the shares or seek a claim in the CIRP of the corporate debtor. They should have sold the shares insofar as the claim is concerned in the CIRP of the corporate debtor. Now, what was further analyzed and held was that clause 6.1 and 6.2 of the pledge document draws a clear distinction between a mere transfer of the pledged shares in the name of the pawnee or its nominee as a beneficial owner and the actual sale of the pledged shares. The right to sell is without prejudice to any other right under applicable law. Thus, there are two stages before the pledge can be enforced by a sale. Now, obviously, that comes out from the section 176 of the Indian Contract Act. At the first stage, the pawnee must give a notice to the pawner under clause 6.1 to exercise the rights to have the pledged share transferred in its name or its nominees. This does not result in discharge of debt equal to the value of shares. The discharge of debt in whole or part occurs when the pawnee exercises his right to sell the shares after giving 5 days notice to the pawner in accordance with clause 6.2 and sells the pawn. So therefore, when we saw regulation 58, it started with those 4 words that subject to the conditions in the pledge document. In this case, the document provided a mechanism that before a pledge can be sold, 2 things are required to be done. One, that a notice has to be given under clause 6.1 for transfer of the pledge shares, which were 31,80,678 shares, to be transferred from MHPL's name in the name of PFISL or its nominees, which will then in no manner mean that the debt has been discharged. Mere transfer will not mean that the debt stands extinguished or discharged. The second condition, which is not in the alternative, in fact, it was the second condition, which says that discharge of debt in whole will happen when the pawnee exercises his right to sell after giving 5 days notice. So this means that the claim of PFISL would have been discharged even prior to CIRP if they had exercised their right to sell those shares after having given due notice of 5 days to the corporate debtor, to MHPL, in accordance with clause 6.2, and having exercised then and then having sold those shares would then mean that the debt was discharged. Now, this is very relevant because ultimately everything will revolve around when you look at a claim that whether the debt has been discharged or not. So therefore, what is important is that you will have to look at the documents, being the pledge document, the loan agreement, and then look into the Contract Act, which is 176. So therefore, first, those clauses will have to be seen that whether the conditions in a pledge document have been met by the claimant or not. If those conditions have been met, then there may be a claim, there may be a discharge of that debt. So therefore, it is very relevant for the purposes of verification of claim by an IRP that he looks at the pledge document, the loan agreement, and then look into the law. The first and foremost is look into the pledge document, whether any condition is prescribed or a mechanism is prescribed for purposes of discharge of debt. Now, after going through all the documents, the provisions and the acts of different provisions, including the Contract Act, the Depositories Act, what Honorable Supreme Court observed was that PIFSL, which is the appellant, has not overlooked its obligation under section 176 and 177 of the Contract Act by relying upon sub-regulation 8 to regulation 58, which has an entirely different object and purpose. Now, what is sub-regulation 8 to 58? Let us just see what we just saw. So, subject to the provisions of pledge document, the pledgee may invoke the pledge, and on such invocation, the depository shall register the pledgee as a beneficial owner of such securities and amend its record accordingly. Now, if we look at 58.8, it says subject to. Now, subject 2 was two conditions, clause 6.1, 6.2. 6.1 provided two conditions. One, that let's go further. The next one. Yes. Now, the first one was that at first stage, the transfer must happen in the name of PFISL, and then the sale must happen. So, two conditions prescribed. Now, go further. Yes. Now, what Supreme Court held was that the appellant has not overlooked its obligation under section 176 and 177 of the Contract Act, and they relied upon sub-regulation 8 to regulation 58. Further, the Supreme Court held that recording change in the register of the depository, whereby the appellant as the pawnee has become the beneficial owner, is only enable the pawnee to sell and transfer the shares in accordance with the Depository Act and the regulations. The Supreme Court further held the object and purpose of sub-regulation 8 to regulation 58 is not to nullify the obligation of MHPL, that is the pawner, and PIFSL, that is the pawnee, under the Contract Act, but to enable PIFSL to exercise its right under section 176. It also follows that MHPL is entitled to redeem the pledge before the sale to a third party is made. Now, obviously, that right of redemption is always there under the Indian Contract Act, where that the pawnee can redeem the right by offering the entire debt along with expenses, if any, to that period, if he fails to perform within the stipulated time. So these three things the Honorable Supreme Court held, and thereafter, in conclusion, what was held was that the registration of the pawn, that is the dematerialized shares, in favor of the appellant as the beneficial owner, does not have the effect of a sale of shares by the pawnee. The pledge has not been discharged or satisfied either in full or in part. So I will just pause here for a moment, because you see, ultimately Honorable Supreme Court held that because under the pledge document, there were two conditions required to be met. One was transfer, other was sale. So what the Honorable Supreme Court held, that yes, the transfer may have happened and they may have become the beneficial owner, but because the sale did not happen, or they did not exercise the right to sell the pawn, which was the shares pledged, the debt was not discharged either in full or in part. PIFS, it was further held that PIFSL is not required to account for any sale proceeds which are to be applied to the debt on the actual sale. The two options available to PIFSL as the pawnee under section 176 of the Contract Act remain and are not exhausted. In conclusion, what the Honorable Supreme Court then held, that section 176 and 177 of the Indian Contract Act apply equally to pledged dematerialized securities as they would apply to other pawn goods, and mere registration by a pawnee as a beneficial owner of dematerialized shares within the meaning of the Depository Act does not have the effect of discharge of debt. So in sum and substance, what the judgment then lays down is that both acts will have to be read harmoniously. The Honorable Supreme Court has neither held that they will override the provisions relating to the Contract Act, the Depository Act, or the regulations. In fact, the Honorable Supreme Court have laid down the law that it will not be an overriding effect. It will actually have to be read harmoniously, because ultimately the right of the pawnee will depend upon the pledge document and the conditions set out in that pledge document, and they will apply to the pledge securities as if goods were pledged. Second thing which Honorable Supreme Court then lays down the law that mere registration. Now the requirement under regulation 58 subregulation 8 is that one, the depository will have to be there and that registration will have to be there. Now mere registration as a beneficial owner will not mean that the debt for which that security was given is discharged. Until and unless that second condition, which sale, is exercised, only then, and that is subject to, according to me, is subject to either payment in full or in part. Assuming it is in part, then the debt, the remaining debt, the claim will still survive for the purposes of a CIRP. Now, therefore, in conclusion, the Honorable Supreme Court in para 12.7, I've just given the conclusion. So I'll just read one paragraph of the judgment, which ultimately answers the question, which is para 13.1, which says, for the aforesaid reason, the present appeal must be allowed, and the impugned order passed by the appellate authority dated 20th June 19, upholding the orders of the adjudicating authority dated 6 July 18, and the emails of IRP are set aside. It is held that MHPL, which is the holding company, is not a secured creditor of the corporate debtor, namely NNIPL, to the extent of the value of the 31,80,678 shares. PIFSL has rightly made a claim as a financial creditor of the corporate debtor without accounting for the value of those shares in its claim petition. Insolvency proceeding against the corporate debtor, namely NNPIL, will proceed accordingly. So therefore, the appeal was allowed by the Honorable Supreme Court, and the decision of the IRP, the adjudicating authority, and the NCLAT was then set aside. What the Honorable Supreme Court then held was that they are a financial creditor of the corporate debtor, and because the conditions were not met, therefore the debt still survived, and there was no discharge of debt insofar as the pledge is concerned with respect to those securities. Therefore, their claim was rightly made as a financial creditor before the IRP, who had rejected the claim on the ground that you have become the owner of the shares. Now, there is a difference between transfer of ownership and having a right as a beneficial owner, which is a special right. So what the Honorable Supreme Court has held, that you will only become a beneficial owner when a pledge is created. Whereas in a mortgage, there may be a transfer of ownership. That's not same as a pledge. That's the basic difference between pledge and mortgage. That there is no transfer of ownership right. It is only a beneficial right, which will be over the moment the debt is discharged. So therefore, the IRP was required to see at that time whether the debt was discharged in full or not. If the debt was not discharged, the claim ought to have been admitted. But on the contrary, the IRP took a view that because you have invoked the pledge and given a notice under 176, therefore you have become the beneficial owner, and therefore your claim does not exist for the CIRP of the corporate debtor, as if those securities have been sold. Because the second condition was not met, the Honorable Supreme Court held that PIFSL will be a financial creditor of the corporate debtor. So with that, I am open with questions, if any, with respect to the judgment in which we have just discussed.
Yes, sir. I have a question. This is Ashok Jain. Am I audible?
Yes, sir.
Sir, in general, my understanding is that if there is any pledge, with a financial creditor, and the outstanding debt is more than that the pledge amount, even if I realize through sale. For the remaining amount as a secured creditor, I always has a right to claim or go to the IBC, I mean the NCLT for the CIRP, because still my outstanding is not recovered fully. So it is, I think it is a established rule or set principle that till such time I fully received. If there is a liquidation and I get only say 20% of whatever claim amount is outstanding in my books, then it's a different issue. But till such time there is a process, and till such time the process is not fully exhausted, I have the right to to submit my claim, maybe under this latest piece of legislation under IBC 2016 to NCLT. What is your view, sir?
No, sir, that is, I agree to that. In fact, that's the settled principle of law. And that was the provision of Indian Contract Act provides that until and unless the debt is discharged in full, I still have a right against the person who has pledged those goods or securities. And therefore, the Honorable Supreme Court in this judgment have considered that it was not that the securities having been sold, money having been realized, nothing being remaining. And therefore, Supreme Court held that because that second condition, that no sale has happened, I have not recovered. The moment that happens, the debt is still surviving. So therefore, Supreme Court held, yes, you will be a financial creditor. And that's what is provided under the Indian Contract Act as well.
Now, even if there is a sale, and if that sale proceeds are not enough to recover my amount,
Even then,
I have still
you have a right.
In
Yes,
both
yes.
cases, I have the right.
In
Whether
both
it is
cases-
sold, whether it is not sold, my right remains.
No, yes, sir. If we look at, yes, you are right. If in both eventualities, if I have, assuming I sell,
Okay.
and there is a debt remaining, even then I can file a claim and I will be treated as a financial creditor. That's what
Right.
the Supreme Court
Yes.
said. Assuming the second eventuality, that I do not sell, in that event, in any event, my debt is surviving. So
Correct.
whatever, so Supreme Court has said that you will have to read into not only the pledge document, but also to see law, both ways. One, you will have to see the conditions under which that pledge has been given. So therefore, you will see whether those conditions are met or not. If those conditions are met, then you will see whether there is any debt still remaining. Assuming in this case, PFISL would have sold the shares.
Yeah.
And there was still debt remaining. They would still have filed a claim and they would still have to be treated as a financial creditor.
Yeah. Thank you.
Thank you, sir. So I think if there are no more questions, then Anu, you can take over. Thank you for giving me this opportunity to present the judgment to all the learned insolvency professionals. Thank you.
Thank you, sir, for such detailed discussion. Thank you. It was very informative. We learned a lot from you. Thank you. Thank you to all the participants also for taking the session and making it interactive. Thank you.
Thank you.
Thank you.